All right, according to Mr. Maury, the CPS is no longer involved. They've closed their case. Is that true, Mr. Maury?
Correct. And they both told me to go back to the court ordered.
Right, but I need to know that CPS has closed their case. Ms. Maury, did they close their case?
Yes, they did, but CPS also did not fully do their own investigation. They were going based off of law enforcement's lead.
Well, and both have that equal ability to investigate, and therefore parenting time goes back by law to what it was ordered.
Okay, well, I can tell you right now that even though the police and CPS told me to go back to parenting time, the police also told me that there was not enough substantial evidence
Correct.
to take him to court, but
Correct.
that does not mean that he is innocent.
No,
and I'm not going to send my girls
all right,
back to him.
Ma'am, Miss Maury, let me tell you how this is going to run. Okay, the court needs clear and convincing evidence to stop parenting time. Child Protective Services and the police require a very low burden. So the court, by law, has to order that parenting time occur. Okay, I'm not going to hold it against you during the time period that that they were investigating. But if the investigations are closed, they may say he's not innocent, but the law says there is a presumption of innocence and they don't have the evidence. So yes, by law, parenting time goes back to the way it was ordered.
Okay, I hear you and understand that, but I am not going to send my girls back to him.
If you do not, Mr. Maury, you have the right to apply for parenting time show causes, just as there's show causes for child support. Ma'am, you have to understand that the court will hold you in contempt for noncompliance of a court order.
I do understand that. And since the investigation had been launched and closed, my daughter has been in counseling. Understood. And more has come forward as to what he had been doing to her.
In that case, the counselor needs to alert Child Protective Services that there is more.
She has been making reports, yes, but Child Protective Services thinks it's a joke, and they have told me that it's a Kent County matter, and I have not been able to get in contact with Kent County CPS. No one is wanting to listen to my daughter.
Why is there another county being involved?
Well, I live up here in Clare County, and Spencer lives in Kent County, but it happened down in Kent County.
Right.
Which is where I launched the police investigation.
And that's where Child Protective Services should be doing their investigation.
Nope,
and sir, if it has not been fully investigated, she may be exonerated from contempt. Both of you have your right arguments. What I'm telling you is where the law stands now.
Yeah, so CPS and
I understand that you're going to have to show that CPS closed those cases because you're going to need something in writing to hold her in contempt. So you guys are at an impasse right now, and so am I. By law, if they've closed their investigations, it has not been shown that there is a problem for the child. The counselor may have more information, but that's in the counselor's hands. She's a mandatory reporter.
Okay, then do I have to go down to the courthouse to file that motion?
You can file motions through the Kent County front of the court to work on parenting time and how it should go. They may or may not help you, just as CPS may or may not help her. Like I said, you both are stuck at an impasse right now. If there are more allegations coming out, there may not be an ability to give you parenting time. And new allegations, she has the right to show to the front of the court and show why she's concerned. If she has a justifiable concern for the safety of the child, she has the right to withhold the parenting time. Problem is we don't have any of that paperwork. So I don't have anything showing CPS closed their case, for one. And I do have the note from the counselor, but that's back in August. So, and it was very sketchy. There was no concrete allegation. There was a bald statement that had no background. So that maybe nothing was investigated, or everybody went, well, if the counselor has more, she better alert the proper CPS authorities. And that would be, she would have to contact Kent County. Yes, ma'am.
Just a quick question. I had already filled out the correct forms and everything to release everything to Judge Bryant for the judge to be able to get a hold of the thing that my daughter is going to counseling.
The court does not go out and get evidence. We only review evidence brought to the court. No, we don't make phone calls and stuff.
Okay, I have an updated letter from my daughter's counselor. So who do I need to mail that to?
You would want to file a motion on your own behalf concerning parenting time with updated information. Right now, the only information that had filed was the letter from the counselor from August stating that there was a problem. And Mr. Maury's motion that says that Child Protective Services and the police stopped their investigations and there would be no charges, and they did not substantiate the underlying allegation.
Okay, so you did not take a look at what I had already mailed down there
The only thing
to
that,
Judge Bryant.
the only thing that I received from you is the letter from Community Mental Health. It is not dated. Luckily, the first line says I have been working with the child since August 19th. Does not say when these allegations were made. Okay. This is the only letter the court has received. That's it. Okay. If you're going to act as your own attorney, you have to take the consequences of that happening. You have to file them orders appropriately. Okay.
Okay, well, I will definitely be doing that.
Please do. And maybe the
I-
impasse will be gone one way or the other. You both are where the instructions are right now is that if the Child Protective Services investigation is closed, and you have the right also, Ms. Maury, to object to this motion, this order that I'm going to issue. Okay.
Yep, which I do fully object because I do
Well,
not
then-
agree with it
then-
whatsoever
then you
because
may-
the law is not doing anything to protect a
I
six-year-old girl.
just tried to
and a 2-year-old daughter.
explain to you what the law is.
Yeah, and the
Okay.
law is
Not
ridiculous
always,
because they're
the law is
protecting
not
the
always,
girl.
the law is not always correct. But it is
No,
the
it's
law,
not.
but it is the law. And we are all presumed to abide by it. So I've given you instructions both on how to do so. So yeah, at this time, the former orders will be enforced.
So I'm just gonna say right now that it's not gonna be enforced and the girls are not going back down there. I will be filing the correct paperwork to.
Then I suggest you
change the
do,
time, et cetera.
this motion is done before you say something more stupid. Have a good morning. You don't
You
look
as
at it, you
well.
don't look at a police officer and say, I'm gonna be speeding out of here after you've given me the ticket. Have a good morning.
Sir, I have something to say along with our agreement. In our agreement, it says my pickup time is 11 a.m. I was wondering if you would be able to reissue that for 4:30 p.m. because
I'm not changing anything.
no,
Have a
I'm
good
only
morning.
I'm only asking because friend of the court says they won't do anything to enforce that for my pickup time at 4:30 for my kids at the meeting point because Cora is in school. She gets off the bus at 3:30. It takes them an hour to drive to the meeting point.
I'm gonna let this go. I'm going to let this go. And if she files the objection, bring that up to the judge.
Okay, I will.
That would have been
Thank you.
nice to know in the paperwork. Thank you. Have a
All
good
right.
morning.
So welcome, everybody. We are here in the matter of Reed versus Streeter, case number 23-01724, DP. And yes, it is your motion. I guess I read this as the defendant's motion, but Ms. Reed?
Yeah.
What do you have to add to this?
Nothing. This has been going on for like 2.5 years. He asked me to put him on child support so that he could get a DNA test. And he keeps telling me he's going to take it. And he hasn't taken it. And now he's defaulted as my daughter's dad when there was some doubt. The doctors were wrong about my dates. And so.
And
like,
you never had the opportunity to ask for a DNA test because that's not your right, it's his.
Right. And he asked me to do that so that he
Well,
could get it.
This case was brought by the state of Michigan, not by either one of you. So Ms. Smith-Lowe is here on behalf of the state of Michigan. So I am going to ask her a couple questions. Like,
Okay.
Ms. Smith-Lowe, what's your input?
Oh, Your Honor, obviously the child is 2 years old, so it's a
Right.
timely motion.
Correct.
Ms. Reed, I believe, is still receiving public assistance from the state. And so if the court is inclined to order genetic testing, it can be done by our office.
Okay.
I know that the court is going to have to make a best interest finding at some point, so I
Right.
defer to the court.
Well, and has he seen the child?
No,
Okay, so he's not been involved with this child.
never.
Do you know who the potential other father could be?
No.
No,
Now that poses a problem for us.
that does pose a problem for everybody. But I'm also not going to put on I'm not going to have him pay child support if he's not the real father either.
Right.
But if he doesn't cooperate, you might want to tell him that he's going to be stuck with child support for the next 16 years.
I've been telling him
Is
for
that-
2.5 years.
Yeah. So if he doesn't cooperate, it's coming after him and there's nothing I can do to help him. He needs to get engaged.
I also
Oh.
have just gotten a PPO against him because he just keeps threatening and harassing me to drop the case and take him off child support.
Tell him that you cannot. This is the state's case. And if he
He
ever shows
does
up,
not understand.
if he ever shows up, I'll be more than happy to explain it to him.
Yeah.
Okay. But I'm gonna grant the
tried.
DNA order. Tell him that this is the only way that the court can deal with the case. Okay. Ms. Smith-Lowe, thank you.
Your Honor.
I'll have some questions for you at some point. I had another case this morning, which was a DS case.
Mhm.
They have a divorce case from 2 years ago. Same children, same everything. You filed a separate case.
My case?
No, it's one of the other prosecutors, but I know
Oh.
that you run. So I'm going to talk to that prosecutor. I'm going to talk to that prosecutor specifically because I'm going to invite them to a settlement conference where I can either combine the cases, dismiss a case, or get the right orders. So I just wanted to warn you.
Okay, do you,
Not
did you want me
right
to look
now.
into it now?
No, I don't want you to look into it. I just thought I'd give you a heads up.
All right, thank you.
Don't worry, we'll send out the proper paperwork.
All right, thank you.
Thank you. Ms. Reed, I'm granting your motion. So good luck. All right.
You know,
Ms. Smith-Lowe, I guess I will see you in 15 minutes.
yeah, I don't have anything with you.
Oh, you don't?
I don't,
Okay,
unfortunately.
then as the head of your department, I guess I'm glad I gave you the heads up. I will talk to the actual prosecutor that did it.
All right, thank you.
All right, take care. But I thought you might want to know.
Yeah, I do. I would like to know.
Well,
I
you know,
appreciate that.
things fall through the cracks.
Yeah, I might follow up with Rebecca to get the case numbers and follow up.
We can do that later. But
Okay.
The problem with it was I just realized that I didn't ask where the divorce is. It might not be in this county. I assume it is because this case was brought in this county, and according to it, they've lived here for 5 years, and the divorce case was, I think, 4 years ago.
Okay.
So I don't know. That's why I'm setting it for a settlement conference to go, let's vet this out.
Okay. Will you do the order on this?
On this one? Yeah.
Yes.
Yeah.
Okay.
Thank you for telling me, because otherwise I'll let it sit. So send for DNA.
Thank you, Your Honor.
Take care. You have a good morning.
You too. You as well. Bye-bye.
Bye. All right, next. Nope, it's going to message. So at this point in time, we're going on the record. I don't need to do anything at this time to get him here. It's his motion, but we're here in the matter of Moore versus Moore, case number 23-10318DO. I will note that Ms. Moore is present, the defendant. Mr. Moore is the plaintiff in this case for the divorce. This matter was set for, well, it was filed in October of 2023. You have 1 year to get a case done. This case was dismissed. This case was dismissed in August of 2024. I'm afraid I cannot grant his motion to reinstate the case.
Well, I was the one that was trying to reinstate it because they was telling me.
Yeah, you have to. Did you file the counter complaint?
Yes.
Okay. Yeah, unfortunately, the case was closed when that happened.
Yeah, well, that's what the lady at the court had told me.
You have to file. Yeah, you have to file a new case, because even when you filed it, this case was over a year old. You have 1 year from date of inception to end the case. Otherwise, we dismiss the case anyway.
Right. Well,
so
see,
since the year has passed,
they was telling me that because I wasn't the one that opened it, I couldn't do nothing about it.
Right. Yeah, there wasn't anything you could do about it. You just have to restart it. Sorry.
Okay.
Wish I could help you.
All
I'm sorry.
right,
I read it and I thought it said the plaintiff was the moving party. I thought it was Justin. All righty, but I'm sorry. Good luck. Take care. This one was a little bit of a confusing one. So, all right, bring in the plaintiff.
Hello.
Good morning. Welcome. We are here in the matter of Jackson versus Jackson, case number 23-03356DM. I have plaintiff, the moving party, present. I do not have the defendant. This matter was set for a hearing at 9:30. And he is not here, and it's 10:18 or 10:22. Ma'am, your motion says that you got recent paperwork regarding an error in child support.
Yes, so I recently, oh, sorry, go ahead.
No. What are you talking about?
I recently had a baby and they linked her case or her file for child support onto his case.
Oh, that's not good.
Yeah, so I have
Um,
to, they told me I had to start the motion to have her removed because he's not the father of her.
when was she born?
August 22nd of this year.
And do we have a judgment of divorce?
Yes.
Okay, so the judgment was, I found it. The judgment was entered on November 27th. So this child was born, when did you say she was born?
She was born August 22nd.
December, January. So that's within 10 months, correct? Of the
Yes.
judgment entered. Unfortunately, the policy is that if a child is born within 10 months of the divorce entry, the child is still legally the father's. We have to jump through the hoop to make that happen. So what I need you to file is not a motion regarding support. I need you to file a motion regarding revocation of paternity.
Okay.
Okay, because I need the child's name, the child's date of birth, well, the child's age and the child's date of conception. Because I need to know that it happened after you guys
Okay.
were separated. And then what I will do is
Okay.
grant you a hearing on that. So
Okay.
if I can, I'll make this easy on you. You file the motion, and if I can find it, I'll grant the motion to a hearing.
Okay.
Okay. That way you don't have to take off another Friday morning.
Yeah. Thank you.
All right. Because this one's kind of an obvious one. I probably will not grant DNA testing simply
Okay.
because it's supposed to. A lot of people read the statute to say that we shall grant DNA testing. They forget the last lines, if it will assist the court.
Okay.
But I trigger the if it will assist the court, and you guys have been separated since 2020. I doubt that a child born in 2024 is going to physically be his.
Yeah.
So
So I
welcome to
appreciate
a
it.
little glitch in the law. But I need the appropriate
Okay.
motion to state that the child was not part of this marriage. Okay.
Okay.
That way I
And
can grant
then,
you the appropriate motion. I mean, the
so
appropriate order.
what's the order name again? I'm sorry.
ROPA, Revocation of
ROPA.
Paternity Act.
ROPA. I can remember that.
Otherwise jokingly referred to as the Maury Povich statute.
Okay. Thank you.
Okay. Have a good morning. Take care.
Oh, I
Yes.
also, it was
What else?
another one. I have to also, they told me I have to file the motion for a review on our case.
All right, what kind of review?
Financial review. I think that's
You
the
want a
name
child
of it.
you want a
Yes.
child support review.
Yes.
Okay. It looks like one was just recently done in September. Did you
Nope.
receive that?
So she told me that I had to, because I was going through having a
Okay,
baby.
I will file. This
Thank
is
you.
a motion for support, so I will send it for support.
Thank you. ROPA.
Okay.
You
ROPA.
have a great day, sir.
5th floor, the Legal Assistance Center can help you do that.
Thank you.
No problem. Good luck to you. See you again in well, maybe not see you in a couple weeks, but maybe 3 or 4 weeks when I can just grant you a hearing. Okay.
Okay. Sounds good. Thank you.
Yeah. And somehow I got to put a note on this that way I don't waste any of her time or his time. Seem to be having a lot of those lately where children are born within that 10-month window, which I don't understand. Okay, next.
Next, we can do Jones versus Suggs. I just have plaintiff here who is not the moving party.
All right, depending upon what the motion is. Let's see what it is. Good morning. Welcome, Ms.
Hi,
Jones. How are you?
I'm good. How are you?
So far, so good. All right, we are here in the matter of Jones versus Suggs, case number 18-05124DS. This is Mr. Suggs' motion, not yours, and he is not present. This matter was set for hearing at 9:30. It is now 10:27, so he's been given plenty of time. My question to you is, do you have a response to this motion? He motioned to have child support reviewed. So the question is, you always got to be careful with that. You know, when you ask, it can go up, it can go down. I've tended to note that people that wanted to go down, it goes up, and I've tended to note people that wanted to go up, it goes down. So we do have the ability to review it because there was a change, but I don't know whether because he's the moving party, not you. Any input?
I would just say to go at, it's okay, it's fine if it's reviewed,
Well,
because I feel he's gonna motion again.
Right, that's why I'm asking. Gee, you got it without me saying it. Because otherwise what happens is we get this, I've had up to 5 motions refiled on stuff like this,
Yeah.
where one party will show, then the other party won't show, then the one party shows, then neither party show, then it's like, okay, so that's why I try to cut the the play area here and just say, all right, it's appropriate. I'll send it to the front of the court for child support review, and we'll see what happens.
Okay.
All right. You have a great morning. Thank you for your
Alrighty.
patience, Miss Jones.
Thank you.
Yeah, that's my fear on the other cases where they didn't show. It's like, eh. Okay, next.
Wooster versus Mink. I just have defendant here.
I figured we only had one parties left because you only start bringing in one parties when
Yeah.
both parties are not present. Okay, all righty. Mr. Minky, welcome.
Welcome. How are you?
So far, so good. We are here in the matter of Wooster versus Menke, case number 15-01354DS. So that you don't get confused in the future, the plaintiff always stays the plaintiff. Just because you become the moving party does not put your name in the plaintiff slot for the motion.
Yes, sir. I realize that now.
Then we get flipped back and forth about who's who.
Yes, sir.
That's only because I do maybe 20 or 30 of these on a Friday morning.
Oh, wow.
Sometimes your eyes get crossed, or mine do anyway. In any event, so your motion, now that I've case number, let's see, Menke versus Wooster, case number 15-01354DS. Your motion is concerning child support because you are currently on SSI, correct?
Yes, sir.
I have an order that was signed on June 27th, 2024 that sets this child support at 0 as of May 1st. Because you're on.
Yes,
Yeah?
sir. I just got that after I had filed the motion. So, but I wanted to make sure I kept the court date.
Just in case.
Yes, sir.
No problem. So you have your order, your request has already been granted, and it was granted a couple months ago. Sorry for the delay in the mail.
Well, you know, I'm glad to see. I'm glad to see that it did. You know.
Yeah.
Something
Yeah. It's kind of an automatic when people get SSI. We can't collect on it under federal law, and the front of the court gets alerts.
Okay.
For those things, so they tend to file that so that they don't chase their tail trying to get money that can't be gotten.
Right. Right.
And then we explain to the receiving party that there may be benefits for them if they apply.
I'm glad because I have not had any contact with Joey. I can't seem to locate her at all.
Well, I wish she was here because I would be able to inform her that she may be able to apply for benefits.
I've been trying. I've gone through her mother, everybody. I can't locate her to tell her.
Well, just, at least notify those that you can that she has the right to apply for benefits.
Okay.
All right. Thank you, Mr. Mackey, but your motion's already been granted.
All right. Thank you very much, sir.
Have a good day. And I'm glad you kept it just in case. You never know.
Absolutely.
I would have thought that you'd have gotten this in August because it was done at the end of June. So now, Lord only knows.
Now, I have a quick question. She's been withholding my kids. I haven't been able to see them in quite some time.
How long has it been?
It has been years. It's been.
Oh, good God.
I know. I've been dealing with my.
You have the right to file the appropriate motion.
Okay, so just stick.
Yeah, I can't just do that out of the blue because I need to know the background.
Okay, I do. I'm already in the process of filing that motion.
Okay, because there's a huge difference depending upon length of time you haven't seen them and their ages.
Yeah.
And why you haven't seen them.
Now,
as was discussed in a previous case this morning, I find out that, yeah, she disappeared out of the house because the landlord was selling the house and they separated and she hasn't let him see him because she applied for a PPO because it was an issue of domestic violence, none of which was in any of the paperwork. So I need to know background. I've had guys that come out of prison and stuff like that, and that's why they were separated. Just that you haven't seen the kids in a while is not the final statement. I need to know why and how and what's going on. So please post that in the motion and hopefully she will appropriately apply. That way the court will have enough information.
Now, do you know what motion that is?
I can't.
Exactly.
I can tell you to file a motion. That's the most I'll go for.
Okay.
Legal Assistance Center on the 5th floor of the courthouse can assist you.
Okay.
Okay.
Thank you very much.
I try to guide this morning as best as possible because if I can limit motions or help people with, and disengage from the court as much as possible, but sometimes that's not possible. And sometimes I kind of hedge that giving legal advice, but I try not to give legal advice. I just try to give procedural direction, which is
That's
allowable under the law.
understandable.
Okay.
That's understandable.
So procedural, I can tell you, file a motion.
All right, that's
And I can say,
understandable.
the title of it should be parenting time, but that's as procedural as it goes, and good luck.
Okay, well, that's I think that's all I need to hear then.
Thank you.
Thank you.
Have a good morning.
You too.
Okay, next. Okay, we are here in the matter of West versus Blunson, formerly Blunson versus Blunson, case number 15-04065 DM. Ma'am, this is your motion. What do you care to add to it?
Just want to add to the fact that it's been since 2015 we've been divorced.
Right.
It was 7 kids involved in the divorce, and
Yes.
he's paid $32 every 2 weeks since
Well,
then. I just feel like that is not
I know
right.
that so that I could explain to you, you could have asked for this to be reviewed every 3 years.
I know, I just learned that.
Yeah, no one ever asked in the file. I mean, we would prefer to leave you alone because we don't want to. Yeah, but it looks like there's only one child left that's under 18.
Nope, there's 3.
There's 3. Okay.
Yep.
Okay. You have the right to ask, and it's an automatic. We will send it to the front of the court for child support. Do you have any questions, Mr. Blunson?
Yes, sir. Far as that goes, she won't let me see the kids. I can't be involved in them with them whatsoever.
Okay.
She's saying I haven't did nothing since 2015. She took that away from me. Like
okay.
she
Then you need to. Then we are here on a child support order. You need to file a motion on parenting time.
All right. Well, no problem.
Because again, I'm assuming that since there's nothing in the file, I'm assuming you guys, everything was going smooth and you were seeing the kids and she was fine.
No,
I was working 2 jobs.
Like I said, there's nothing in the file that says there was any problems. The only thing before me is a request for a child support review. And since I don't know what the past almost 10 years has been,
okay,
I need you to put that in writing and figure out that way she may respond to it appropriately and say why it would be or would not be appropriate.
Okay, I want to say I filed that motion. I sent it to her house. I want to say I dropped it off there. I have the copies in my hand right now.
When did you set it for?
I never received the motion. I received a bunch of paperwork.
I don't have anything in the court file.
Because he didn't file a motion through courts. He sent the paperwork to my home, which is harassment.
Yeah, you have to file the paperwork through court.
That's harassment.
No, it's not. Filing paperwork to try and get parenting time is not harassment.
If he filed paperwork through the court office, yes, they sent paperwork to my home, not a court paper.
Well, again,
a bunch of letters.
Hold on. A request for parenting time is not going to be considered harassment by the court.
Okay.
Just to let you know, people have the right to ask to see their children.
That's correct, but I'm telling you, the paperwork that I received,
what I'm going to do.
From his girlfriend.
All right.
No papers through the court.
Okay, Mr. Blunson, file your motion, and we'll see you for that motion. Okay.
Okay, no problem.
And ma'am, I'm going to reserve the date of starting child support as 11/1, but and I'm going to send this to the front of the court within 2 weeks, but I'm going to give him 2 weeks. If I get that motion, I'm going to combine the 2 motions because that way it can be looked at in total. Because otherwise it's two different departments. One of them does child support, one of them does parenting time and child support.
Okay.
If I only send it for child support, it goes to the one division.
Yeah, because the child support is what we're here for.
Right. And I'm only going to give him 2 weeks because I'm not going to hold it too long, but you have a reserved date of start of the child support is November 1st, one way or the other. But then if he does file that and I do send it to the front of the court, which I will likely do, by the way. Okay, but the reason I need the motion is because I need the front of the court. Like I said, this file is pretty empty of any information. That motion should contain that motion should contain information, and you should respond in writing that contains information as well. That way we can send all that information to the front of the court so they have a starting point on working with you with that. So, sir, if you do not file that appropriately, I'm sending this just for child support. Okay.
All right, no problem, sir. Thank you.
Good luck to both of you. May see you in a couple weeks. Take care of yourselves.
Yep.
But your motion is granted, Ms. West. One way or the other, we're getting child support started on November 1st.
Thank you very much.
Okay. Yeah, it starts the first of the month after you filed it. You filed this in late October, so it'd start November, no matter what. Okay.
Oh, okay. Thank you.
Have a good morning to both of you. Good luck.
You
Look
too.
forward to seeing you again.
Yep.
Welcome, Ms. Biles. Mr. Collard is not present. Do you
Well,
know?
no, I don't know why. And
Okay.
he definitely know he had court today, and I even texted him this past weekend to
That's okay.
update
I was just
stuff.
wondering if you knew something that I didn't, for the
No.
record. That way, because, okay, if you don't, and he should be here and he knows about this, we're going to
Yes.
proceed. This matter was set for a hearing at 8:30. It's now 9:11. So I've read your motion. I had some questions.
Yeah.
Has CPS been involved? Child Protective Services.
The problem is I've tried, so they were in 2019 because there was,
Right.
it was domestic violence. And then, I was able to finally like separate
Okay, but
myself.
that violence was against you. And that
Yeah.
was 2 years before this case was, well, this
Yeah.
case is a 2021 case. So that was 2 years before the case was even started. Now we're dealing with alleged harm to the child. Has CPS been involved with that?
I've called CPS. The problem
Have you taken the child to the doctor for some of these injuries? Because some of them look like they could be looked at by a physician.
Yes, yep. There's been a few times I've had to bring my kid to the urgent care.
When was the
Because
last time that occurred?
It's been within the past year because I
Okay.
mean
And they did not alert Child Protective Services.
No.
Okay, because they are mandatory reporters. If they believe this was harm to the child intentionally perpetrated, they would have alerted CPS. If they did not, they would not. And trust me, they pull that trigger often.
But they don't see. Here's a problem. I've even made with the sheriff's office. I went down there and I made a report regarding this abuse. Like the burn marks, everything. And then I've called 3 more times, like regarding like these incidences, and it's just still an open investigation.
Well, he seems to have some type of an explanation for the burn mark.
There are 2 different incidences with the burn marks, and they were treadmill incidences, both of them. And these occurred within a month of each other. And the first ones look like cigarette burns on him. And they said that.
Well, the ones I looked at didn't look like cigarette burns, but okay.
So the ones like on his arm, like that's the second one. But if you look through the text messages where he's saying, "Oh, I wouldn't send my child to the grandparents unless it wasn't safe," and I said, "Is this safe?" And you'll see another picture of the
I can't bubble wrap children. I'm just trying to figure out if he's intentionally harming the child or if these are accidents, and there's not much either one of us can do about it except patch him up and let him heal. That's the questions I'm having, because if a doctor has seen these and did not alert Child Protective Services, and the police have looked at this and not alerted for Child Protective Services, that leans toward there being more of an accident than they are anything else.
These are consistent, though. That's
I understand that, and some kids are klutzy, but I have concerns. What I'm trying to determine right now is if you've reached a level where I would suspend parenting time this morning.
I don't want.
I am sending this for a custody, parenting time, and child support review. You have enough here to say there are concerns. Therefore, this does need to be looked at. The reason for my questions this morning is I need to know if it legally rises to the level where I could suspend his time.
Yeah, I filed an emergency ex parte.
I know, and it was denied because of that. Because Child Protective Services is the one who normally does this, and so do the police. And they both, the police and doctors have looked at this and not triggered the right system, which means there's indication that this is not intentional harm. I'm not saying that it's not a problem. I'm saying it's not intentional harm that I can stop parenting time for and suspend it right now. But I am going to grant your motion to have this looked at for custody, parenting time, and child support.
It needs to be, but the problem is like when I had talked to the sheriff's office, they said they normally do call CPS. They asked me if I've called CPS. I said yes, but when CPS comes to your door, you don't have to let them in. Not only that, it's very easy.
Normally, if you don't let them in and you're the one that they consider might be harming the child, they may come to court to say, because they do need a warrant to go in. Sometimes, and then if you refuse, that doesn't mean you're off the hook. They tend to come to court to get a pickup order or something else, or they come to court to initiate services, and they tell you to withhold the child, and they make a safety plan until they can. That's my problem. None of that has been triggered. I don't know why. I'm just saying that the people that look at this, that have looked at this in depth, are not triggering. They're not seeing that this is an immediate emergency. I'm not saying I'm not saying it's not a concern. I have concerns. That's why I'm sending it and granting your motion. The only thing I was trying to consider is whether to suspend right now or not. And at this point, I don't have the legal level to suspend. I do have the legal clear and convincing evidence by these pictures to say something's happening and something ain't right. But whether it's intentional or not, I can't.
It's negligence though, and then he was involved in a car accident. I mean, there's been
The key word there is it was an accident.
No,
That's why.
like car accidents. There's been car accidents also, and there was one recently where my kid was in the front seat.
Was your child harmed?
He had marks on his stomach.
Okay, did he have to go to the hospital?
No, he didn't have to go to the hospital.
How old is this child?
My son is 5.
Why was he in the front seat?
The grandpa.
Like I
That's
said, I'm sending this to the front of the court because you do deserve to have custody, parenting time, and child support reviewed, but I don't have the legal level to suspend. Not this morning.
It needs to be because there's very serious issues.
They're so serious that the police have done nothing, and CPS has not been triggered, and the doctors have done nothing.
No.
Okay.
And
I'm granting your motion to the extent that I'm going to grant this to be reviewed. The fees are waived. Okay.
All right. Because I do have.
Put all that together. I know you have a lot of concerns. I have concerns too. I just have to meet certain burdens about doing, I can't shoot a mosquito with a shotgun.
May I ask a question?
Of course.
Real quick? Okay. When I started reporting, like, as far as like burn marks and stuff to the sheriff's office, and this, I believe, was back in like April or May, there were more incidences after that. And the problem is like when I'm telling them I have more evidence to show things, the sheriff isn't calling me back. That's the problem. After like the initial stuff, I gave them legitimate evidence. So it's like, and they say it's like open, but nobody is like taking it.
Have they decided? I'm taking it seriously. That's why I'm sending it to the front of the court. Put all that together. They will look at it all.
Okay. So like, what do I do? Like, they just get something like from them, or what?
Yeah, they'll be contacting you in the next couple of weeks.
Okay. All right.
Okay.
Yeah.
I'm sorry I can't pull a trigger that I would like to pull, but we do that hesitantly.
I'm just trying to help them.
I know, and we're going to see if we can get you that help and find out what's going on. The front of the court, if you have the doctor's reports from the emergency room, I would suggest you put those together. Any police reports put together, any contact information for the police that are the sheriff that's involved, the detective that was assigned, and any other information that you have. Okay. Let's get you and this child through this and find out what's going on.
Right.
Because I think there's something, I just don't know what it is.
It's
and
the
again,
grandparents. He's not.
So it's the grandparents. Well, then it may be that there comes a time that we order some people not to be involved with the child at all. If he's not the one, and maybe that's the glitch, he's not the one doing any harm. He's letting the kid go with people that are doing harm, in which case the court can order that the grandparents not have any contact.
That's what it is.
Well, then ask for the correct thing when you're at the front of the court too.
Well, I've tried. I've been trying.
Yeah. And I'm taking you seriously. I'm just not taking you to the point of saying I'm going to suspend his parenting time right now.
I understand that.
Okay. Good luck. The front of the court will be contacting you shortly. Get all that information together. That way you have it all. Don't look at them and say, I have more. You need to take it then.
Okay.
Okay.
All right. Thank you.
Good luck. I was just noting to my clerk that I had a question about whether you were served with the motion. So I was going to make sure that you were here before I did anything, because he has no addresses for you or anything on this paperwork. So I wanted to make sure you knew about this motion first. And second, my notes indicate I need to hear from you before I make any decision. So let's go on the record in the matter of Dean versus Jones, case number 20-07870DP. I will note that Miss Dean, the plaintiff, is present. Mr. Jones, the moving party, isn't. He's the one who filed this motion, and he's not here to tell me what he wants and why he wants it. Any thoughts, Miss Dean?
Well, he says that he wants to see his daughter, but I'm not really sure because our original plan was to like go through his mom. Like if he really wanted to
Right.
spend time with her, he contacts me through his mom
Right.
because of the issues we've had in the past. But I guess he didn't want to go through her this time.
Okay.
You
know,
and
bottom line, parenting time currently is ordered reasonable as agreed. Okay.
Sorry?
Parenting time currently is ordered reasonable as agreed, which means you have
Yes.
control. If you don't agree, there's no parenting time. If you want to get parenting time, you make the arrangements to make sure that it's safe enough for the child to do so. Parenting time should occur by law. Parenting time is supposed to happen if it can be done safely.
Yeah.
Now sometimes that's the tail that wags the dog. Sometimes it's the other way around. But my question is, do you need a specific order? Because I'm going to give you the control here. You either keep it as reasonable as agreed, which is what it is now, and you control all of it, or I send it to the front of the court and they'll make a recommendation for when specific parenting time can be done. But normally that's done at the request of a party. The requesting party ain't here to request it. So normally I sometimes just deny the motion, but I also give you the opportunity to say, is there some help you need? Because sometimes the help is we don't do anything because it's better off leaving it the way it is.
If possible for like future visit, I was wondering if we could just do it like through the like where we meet at a place that's, I don't know how to explain it. Someone
Again,
said
you have
to-
control. You have control. You can look at him and say, I'll
Yeah.
give you parenting time, but we meet at this, we do the exchange here.
Is it
That's what
possible
the
we could
current
do it
order
through the
does.
court system? I don't know how to,
If
like where
you
you
do
meet
that,
at a,
if I issue an order like that, I'm going to have to send it to the front of the court to have them review this.
then I'll wait for now because I am fine with
I
just
was going
going
to
to
say
his
he
mom.
may
I don't know
yeah
what
he may come back and follow through with this motion. I need to hear from him. He's the one that
Okay.
filed it. His motion was vague, which is why my notes say I needed to hear from you, because right now it's reasonable and you have control. And
Yeah,
that's
all I
the
want is supervised visit. That's
right.
it. With his
Yeah,
mother there
yeah,
present, I feel
yeah.
more comfortable.
And
with
that
it.
may be the way any parenting time starts, but this case is almost 5 years old. So, you guys have been doing this for 5 years. I'm not sure what he wants or why he wants it. Again, his motion was somewhat vague. So
Yeah.
it's one line. I mean, that's his entire
I seen
motion.
that.
So I
seen
don't
that.
know, I don't know what issues there are, or if there are any issues. It sounds like there are, and you've been doing well. And, if you're willing to give him the parenting time to his mom, that's great. All right, we'll leave it as is. I'm going to deny his motion without prejudice. Without prejudice means he can bring it back, but because it's so empty of any allegations or what's going on, I'm loath to grant anything. That's why I was giving you. I just wanted to hear from you. All right. So he may bring this back, and we'll see.
Okay. If he does bring it back, is it possible where
We're going to send it to, I'm not doing anything on a Friday morning. I will send it to the front of the court when he does. But I want more for the record than one line.
Yeah. Okay, that's fine. Thank you.
And then if you can, respond in writing. That way we have history in the file as well. Okay. The more information the court has, the more information the front of the court has, the better decision we can make. But I've got a lot of people
I can write a letter or something and send it.
You can write a response. Yes.
Response. Okay. I can do
Okay.
that.
Yeah. Because the more information the court has, the better the decision is that we can make. I've got people that come in with these one-line things, and I get 10 minutes of how much they, all this history that's been going on, and I'm like, I'm not prepared for this. I don't know that that's been happening.
Yeah.
Okay. I've had people that come in going, well, he shot his his current girlfriend. That's why I'm like, okay, okay, that is a problem. You don't know what you're going to get thrown.
Yeah, so I would definitely respond with the letter so I can pretty much get everything in there and you guys can
please do so if he refiles. Yes. And I don't know why he's not here. So in any event, good luck to you, but I'll deny his motion without prejudice at this time.
Well, thank you. Have a good day.
You have a good morning. Take care. We are here in the matter of Hall versus Davis, case number 14-00472 DP. Mr. Davis, you're the motioning party. This case is a 10-year-old case, almost 11 years old now. You're asking for DNA testing. There is only, so you're saying for what second child?
Emmanuel Davis.
Okay. Because this case does not involve Emmanuel. Is there a case for Emmanuel out there?
What case is this involved?
Well, wait a minute. They only have the initials. Yeah, this one is Emmanuel. Okay.
Yeah.
I'm sorry. I was thinking Emmanuel begins with an E, it begins with an I. So I got confused because the one last order has only his initials. All right, here's your problem. This case was brought by the prosecutor back in January of 2014. You responded, you asked for DNA testing then.
No, I didn't ask.
Oh, Vondell Davis asked for DNA testing.
No.
Yeah, you did. I've got your response right here. And its signature matches the signature on your current motion.
Back in January?
Back in January of 2014.
Oh, I don't remember that.
Yeah, you say in your motion that you don't remember doing DNA.
Yeah.
I'm telling you, you asked for it and it was done. Not only that, the DNA results came in and you are the father. Based on a report, you guys gave samples on March 13th, 2014. All three of you did, the child, you and the mother. The probability of paternity was 99.999999998%.
I remember the swab for the child before Emmanuel, but I don't remember the swab.
No, this is Emmanuel. The names are right on the DNA test.
Okay, but first, when I did swab for the second child, Israel, he wasn't mine. And I don't remember
well, this case only does Emmanuel. There's only one child involved in this case, and that is Emmanuel.
Oh, okay.
Okay. So I don't know what's going on with Israel, but Emmanuel, you're the father. And I think the test was done by DNA Diagnostics, which is a very competent firm. They confirm everyone's identity. And like I said, your signatures match, or at least they sure do look alike. Okay. You may not remember it, but yeah, you did DNA. Any other questions?
See, I remember.
Well, luckily that's why we keep all the paperwork. So it's in the file.
Oh, okay.
All righty. Any questions?
Okay. No.
All right. Ms. Hall?
I have a question. Yes,
Sure.
sir. I have a question. After this, will we get documentation because our child support is on hold and it's been on hold for almost a year?
Why is it
Just
on
to
hold?
say that I have no idea because
he's on Social Security disability. He's on Social Security income. We cannot collect Social Security income. That's why it's on hold. It's on hold until we find that that he's no longer on Social Security.
Okay. Okay. Yes, because I received just a letter from them as well about the DNA testing, so I was unsure.
Yeah. No, the DNA is in the file, but as long as he is on Social Security income, we cannot collect on it, so it's suspended during that time period.
Okay. Thank you, sir.
That's in accordance with federal law. All righty.
Yes, thank you.
And keep up on it if you find out, Mr. Davis, have you gotten off as a Social Security?
Say it again.
Are you still on Social Security or not?
Waiting on that.
Okay. Well, if something's happening, then we need to review child support in the appropriate manner. So Ms. Hall, keep on top of it. Mr. Davis, if you get a job, we'll need to know.
Okay.
Have a good morning, everybody. Take care.
Thank you.
Thank you. All right. Love it when the motion starts with, I don't remember taking DNA, but I want to take a DNA test. I'm like, the kid's 11. No. Oh, well, especially, I thought that one was going to be a little bit of fun. Just because it was so clear cut.
Yeah.
All right. Who do we got next?
All right. So we're in the 930s now. We can do Hudnall versus Hudnall.
Corey did not show.
No, they did not.
We are here in the matter of Hudnall versus Hudnall, case number 23-00704DM. Sir, this is your motion. You say that the 16-year-old is now living with you, correct?
Yes, he is. He's 17.
Are you 17 now? Miss Williams, is that the case?
Yes, he went to live with him on June 5th.
Okay. So in other words, it's appropriate for me to stop child support then,
Yes.
because he should not be paying you for a child that's living with him.
Well, I didn't think he was paying me anyway.
Well, that's what I think that was my other question. What is current child support?
Well, it was as of June 1st. It was supposed to reactivate if Makai didn't go.
Yeah, because I have it. It looks like it said it's $377 that he was paying you. So, Mr. Hudnall, did you alert the front of the court that the child was with you?
Yes.
Because they normally suspend child support in those cases, especially when the child's this age. And then we set it officially at 0.
Thank you. That's all.
Which is what you're requesting, correct?
Yes, sir.
Are you requesting any kind of a review, or are you just wanting it set at 0?
For now, I just wanted to set it 0 because I've had my son.
Okay. All right. In that case, that is what we will do. Is there any state aid involved in this matter?
Any what?
State aid, Medicaid, my child.
That's another thing I want to talk about. Yeah.
Okay.
Yeah,
so
I want to talk about that Medicaid stuff too, because of the base my son stayed with me, and he doesn't stay where he doesn't do any overnights with her, none of that. And
I get that. What are your questions about Medicaid?
I would like he has his own Medicaid. We both have our own Medicaid.
You have to make sure that you notify the Department of Health and Human Services that he's living with you and that Medicaid should go through your name and your house at this time.
Thank you. That's all I want to know. Thank you, sir.
And
Yes.
Your Honor, I also have insurance on him through my job, and we all was on the same Medicaid record when he was living here. So nothing changed, even though we had joint custody. So I didn't see any. I'm the one that's making the
just so that you know,
just
so that you know, the state may mandate the child's. I'm going to let you guys do what you're doing, but the state may mandate, as soon as they're notified that he's living with you, they may mandate child support set by law.
What you mean by that, mandating it?
The state mandates the child support is set by law because they confiscate part of the child support to reimburse the state for what they pay. But because of the child's age and time, they may say it's a nothing, because I'd love to stay out of your lives as much as I can. I can't when state aid's involved, but once they're alerted, they may make other decisions. I just wanted to warn you of that.
That's what I need. Yeah, I'm trying to.
Yeah.
That's what I wanted to do in the first place.
Okay. So I will set it at 0 with warning you that the state may come back and say, no, we want child support paid.
From me or her?
From her.
Okay. Thank you.
child support for what? Because he's getting Medicaid when I have insurance on him through my job.
And again, that's why I'm not triggering immediately, because that's not before me. But that the state may come in and do this. But like I said, due to the child's age and the circumstances, they may not.
Right, because he'll be 18 in 3 months.
Right. That's why I'm saying they may not bother.
Yeah, this was unnecessary.
Okay. Right. So because that's why I'm willing to set it. I'm willing to set it at 0 at this point, because normally I'd tell you in 2 weeks they're gonna contact us and say we want child support started. But because of the age and the circumstances, and he's going to be 18 shortly. Is he still in school?
Yes, he is. He has a whole year of school left to finish.
Okay,
so with me. I take him to school every day.
Okay, so
that's because you choose to.
All right,
I talk with my son every
it was
day.
a simple question, folks. I wasn't asking you to get into it with each other.
I'm not talking to
so he's a senior?
Yes, he is.
Then both of you enjoy his senior year.
I'm trying
to.
Take care and good luck. But I will set the support at 0 at this time. Thank you.
Yep.
So we are here in the matter of Valdez versus Palmer, case number 15-01472DP. I've read your motion. The one question I had, sir, is you said she left on Monday or disappeared on Monday. What Monday?
2 weeks from this past Monday.
Okay.
This past Monday. 2 weeks from that day.
Yeah, okay. No offense. I just was trying to figure out a timeline here, because you said she disappeared on a Monday, and I'm like, and forgive me, but I've had people that come in with stuff like that, and you find out it was 2 years ago. So timing is an issue. All right, Ms. Valdez, what's going on?
So I have lived at my house for 12 years. Mr. Palmer has lived in and out over the past 12 years. He is never on a lease. My landlord was selling the house. I told Mr. Palmer this.
Okay. Did you tell him in writing, or did you text him, or?
I told him he didn't want to be on my mortgage. He didn't want to be on the utility bill.
That's fine. Then Have you guys reestablished parenting time then?
I filed for child support 3 months ago, and that's when he got violent with me, and I had to file it for a restraining order. They called up his job for a review. I requested help because Mr. Palmer doesn't have medical, so he can't take the case
Well,
to the doctor.
I don't see anything in the file that says that you've applied.
Oh yeah, it was a review. They said that they do them automatically every 3 years. So I got in contact with a friend of the court. They went and established what he makes through his job and mine, how many overnights, and they said that it should go under review for November because they do them every 3 years. They said.
Oh, okay. Then they are automatically reviewing the child support.
Yeah.
So what are you doing with parenting time? He obviously lives in and out of the house, so the kid's safe with him, or you feel safe with having the child with him. What are you guys doing about parenting time? Because you can't withhold the child.
Your Honor, I don't mean to cut you off here real quick, but I do want to explain to you, I have a letter here from the school, from the principal himself, stating, I have a letter here typed out as far as stating my role and what I done there. This letter states that I have taken care of the kids and have picked them up for the past.
I'm not asking that right now. Okay,
I understand.
I get that.
Can I at least get to
I'm assuming that I'm assuming you've been very involved with the children because you guys have been living back and forth.
I have.
That's why I'm asking. I'm trying to set and find out what's happened. Obviously, she had to move from the house.
Right now, sir. Yes. I'm just going to explain. I'm trying to explain as best I can. I'm trying to take my time because I haven't seen my kids in over 2 weeks, and she's
That's
been.
That's what I'm trying to reestablish. If you'll let me.
Okay, I'm sorry. I'm sorry. I just, it's been over.
I'm setting the groundwork for making sure you get parenting time, and let's get you re-involved with your child now. I'm just trying to find a decent way of doing it, and then I'm going to send this to the front of the court for parenting time and child support, so that both are looked at.
And thank you, Your Honor. And all I'm trying to say, Your Honor, is this: that Monday, 2 weeks from this last Monday, I had an altercation with Stephanie in the house, an argument, because I was trying to help my son.
So there was a domestic violence incident.
Yeah, no, it was no domestic violence because I never touched her. Sure. But it was verbally. Excuse me.
Do you really want to keep talking? If you're digging a hole, stop. Put the shovel down. Okay. I figured something happened. I was trying to figure out how to move on without getting into dirty details that are going to be necessary for an actual parenting time order.
No,
I'm just trying to establish, because we're dealing with a child who turns 10 in about a month, right?
Yes, sir.
The file is only got about 20 pages in it, and this is from 2015. So there's no information in this file at all whatsoever.
Your Honor.
Motion was the fact that she stopped parenting time and disappeared on a Monday.
Yes.
Okay. And you are asking to reestablish it. What I'm trying to do is figure out what to reestablish.
We never had a custody. We never.
I got that.
Yeah. So what I'm trying to say is this. All I'm trying to say is the kids were taken out of school and they haven't been enrolled in a school. And I also have feelings about that. He has not contacted me.
All right. Do you want to see the child or not? Because I was trying to get you to see the child. All right. Then let me get there and I'll deal with the school issue second. Okay, let's deal with this with what's important first, which is why I was trying to get you parenting time.
Yes, sir.
Okay.
Yes, sir.
Ms. Valdez.
Yes, sir.
What is the intent on parenting time? He deserves it. He's been involved with this child. We need to get something going.
Yes, sir. It's Darren. If he can just get a place of his own and have a safe place for the kids, I don't mind him seeing them, but he never does that. He never has a place.
Wait, kids. Wait, kids plural?
Yeah, we have two.
Your Honor, I lived with Stephanie for 12 years and we haven't been on and off. I have been in the house the whole entire time.
The landlord sold the house, Darren. We're not on the lease.
All right, I'm done. They are in school. What school are they in?
They are Saranac Elementary, sir.
Where were they 2 weeks ago?
They were at Kent Hills Elementary. That was where my old house was before it was sold.
So you had to move them to a different school district. Now you know the school district.
Close to my job, sir. Yes, close to my job.
Mr. Palmer, now you know the school district.
Thank you.
Unfortunately, here's the problem that I have. She has sole legal and sole physical custody. Parenting time is currently ordered as agreed by the parties. That is the current order. But you guys keep interrupting me, so I am not going to be of very much help to you this morning.
No,
so I
I'm
am
sorry.
sending this
I
to the
won't.
friend of the court. Yeah, you've said that already.
No, Your
so
Honor,
I'm sending
all
this
we're
to the
trying
friend of the court for custody, parenting time, and child support issues. But I will warn you this. There is only one child in this case. The other child has not been legally established with Mr. Palmer as the father. Is there an affidavit signed for the second child?
No, sir.
All right, somebody better file a case to have that second child and make you, Mr. Palmer, the legal father of that child. I would encourage you both to figure out how to arrange for parenting time for both of these children because they both deserve it.
Yes, sir.
But while I'm trying to help you, you seem to keep interfering with my help. Therefore, I am done trying to help. I am going to help by doing the only official channel that I've got.
Your Honor, I'm begging you. I have waited over 2 weeks and I have not went a day without seeing my kids. And it's been over 2 weeks.
And I tried to help you see them, and I tried to help you see them, but you kept interfering and you kept doing things.
I'm sorry.
Yeah,
because
you're very sorry. But what I'm going to tell Ms. Valdez is, do you have each other's contact information?
Yes, sir.
All right. Please contact him and let's arrange for some parenting time. Both of you keep notes about when you see the children.
Yes,
all right. I'm sending this to the front of the court for a full custody, parenting time, and child support review, but it is only on Gloria. She is the only child in this case. Until you said kids plural, the court had no idea there were more than one. Somebody needs to open up a case and make him officially the legal father of the other child. Okay? Because we have no legal case with that kid. So Mr. Palmer, Mr. Valdez, one of the two of you file a paternity action. Okay?
I'll do it now.
Yeah, then you're at the courthouse, right, sir?
Yep, I'll do it now.
Please do so.
Yes, sir.
You guys are sure you did not sign an affidavit of paternity on the other child?
No, not for my son. I did not. I just automatically assumed he was mine, so I did.
No, unfortunately, a child born out of wedlock has only one parent, and that's the mother, because we always know who that is. We do not know who the father is. So you either have to sign an affidavit of parentage, or she is the only parent. That's the way it remains by law. That's why you need to file a paternity action. That's the reason I was asking the question appropriately, to make sure that you did not sign the affidavit, because there's two separate cases. If you've signed an affidavit, you have to file a custody case. If you have not been made the legal father, you need to file a paternity case. Please do so. It's on the 5th floor of the Legal Assistance Center at the courthouse. You may file that. Ms. Valdez, you'll be served those paperwork, and then as soon as possible, we'll combine these two cases so that we know that we can get both kids taken care of. I would encourage at this time, I was trying to figure out times and places. I'm not going to do that anymore because of the interactions here. I would encourage you, because Ms. Valdez, withholding the children does play into custody and parenting time if you withhold the children, so don't. And please, in writing or text, keep him informed of the school. Sir, you now know the school. Please contact the school so that they have your information. That way you may be involved, all right, with the school.
Can I say something?
At this point in time, she has sole legal custody of both children, so I can't do anything about the change of school. You need joint legal custody to have any input in where the school is. So yes, ma'am.
I just had one more question. So because of the last time when the argument started, the Kent County issued a restraining order against Darren for me, and they're also issuing the address protection program for me as well. So I'm enrolling.
So we have other problems then.
Yes, sir.
Your Honor.
Is there? Yeah.
Can I speak, please?
Yes.
The PP order was placed on me when she left the house Monday. She placed it sometime that week.
Oh,
and I got
there's a personal
Saturday,
protection order.
I haven't seen her. I haven't been in contact with her.
Yeah, well, no.
I'm stating that.
The personal protection orders are issued by the event that occurred that split you. So if it's that bad, I'm going to leave parenting time between the two of you and how you can arrange it. I'm not ordering anything. I can't. There's a restraining order now. Gee, nobody mentioned that till the last 2 seconds. So I will send this to the front of the court for parenting time, custody, and child support for the one child. And I'll note on here there is a second child and a case is being filed.
Yes, sir. Yes, sir.
Good luck to both of you.
Thank you.
Hey, the epitome I can't fix in 5 minutes what you guys have been doing for 10 years. Welcome to both of you. Let's see how I can get you through this. So we're here in the matter of Honorable versus Betts, case number 23-05576. And sir, you're asking about communication with your kids. How old are they?
11 and 6.
Okay. And you gave young Terrence a phone, correct?
Yes.
Okay.
I got him
And you pay for that and you pay the monthly bill?
Yes.
Okay. All right. Normally that should, Shamika, we do allow for something like that, especially at that age. He's a little young. Normally we go about 11 to 13 is good for a phone because the younger they are, the more likely they are to lose it. But he's allowed to do that. And sir, she's allowed to, when the young child is at her house, she's allowed to say, I can take the phone for disciplinary action.
Yeah.
Okay.
Sure.
But he may use it to contact you. You should not be contacting him a lot.
Okay.
So that's his choice. You've given him a phone and that way he gets to use it. Please monitor it appropriately. Children still need to learn the lessons of how to use a phone. So keep an eye on it and make sure that you monitor his content, his texts, and his downloads. Okay.
Yeah.
And if you have anybody to blame, tell him the court told you that you had to monitor it. That way it's my fault. And Miss Honorable, you can do it too. And you can blame the court and say the court ordered me to watch over this phone because the court is allowing you to have it, which the court would do anyway. But sometimes it's easy to blame the boogeyman than it is to take, it's not your fault. And the kid might take it better. Okay. Now, what are you suggesting? I mean, I don't know what your circumstances are. We've dealt with the phone issue. What are you suggesting for communication in general?
I mean, the phone is fine. It's just not having a clear discussion on when he gets the phone back.
Right. Well, at her house, it's her rules. So
yeah.
If she removes them, then she has that right, the same that you do. You don't have to do every little thing. Your parenting time stops at her doorstep. Her parenting time stops at yours.
Gotcha.
So, if she has legitimate reasons, she should kind of tell you that at some point, but she doesn't have to tell you when or when it's given back, but you shouldn't take it away from him the entire time he's with you, Miss Honorable, because that just indicates that you're just trying to keep him from talking to his dad. But I'm going to assume that's not what you're doing, that, and when he doesn't clean his room, he doesn't get his phone. If he doesn't finish his homework, he doesn't get his phone. I'm assuming that's all that you guys are working on. Now, is there a court order for parenting time here?
Yes, there is.
There is? Okay. So, yes, I found it. It was buried, sorry. Okay.
So, a really quick, my question on top of that is, I'm paying the phone bill and all that.
Right.
And so she has possession of the phone. And
no, your child has possession of the phone.
No,
when it's
right?
When it's on her parenting time, she may utilize it if necessary to discipline. Otherwise, I'm saying that the child should maintain the phone.
So, yeah, but at this time, I haven't seen this phone in over a month and a half.
Well, that should change right now because of what I'm telling you.
Gotcha. Okay.
I'm ordering that phone be with the child because, ma'am, you're not paying the bill. You don't get to confiscate it forever. You can confiscate it for disciplinary reasons at your home, but then the child should have it. It's his phone, just like any other gift given by a parent. You don't get to keep it. Otherwise, a police report can be filed because you're taking property of someone else.
Okay.
Okay.
And that's totally fine. If I may interject and just kind
Certainly.
of give a little perspective about the situation. I have tried to give Mr. Betts back the phone, but he continues to give Terrence the phone back, and a little.
And he can give the child the phone, and when it's his time, he can give the child the phone.
And that's fine. But what I'm telling him is that, Terrence is Terrence Jr. is here a lot more.
Right.
When he has this phone on his hip, he is not engaged. He is not doing his
And
work.
that's why I'm
He is
saying
not-
for discipline, when he's in your time, you have that right. But when it's his time, and if he wishes to call his father, you should hand him the phone, but then you can take the phone back after the phone call is done. If he's not engaging appropriately, that's part of the lessons of using a phone.
Yes. Okay. Thank you.
You don't get to, he doesn't, Terrence, so that you know, he doesn't get to sit at her dining room table and have his nose buried in a phone during dinner.
Yeah, that's totally fine.
Okay,
I
but I'm trying to
definitely
give you
agree with
I'm
that.
trying to give you the general ground rules of how we do
Yeah,
this.
it
We
makes
try
sense.
we try not to stop somebody from giving somebody a phone when it's at an appropriate age. And like I said, he's a little young, but he's getting there. And I don't know what his maturity level is. There are 11-year-olds that I would trust to do a lot of stuff. There are 16-year-olds I wouldn't trust to touch anything. So
Yeah, well, that's the issue.
Yeah,
We've been
and
finding
if that is the issue, that's fine. But then the phone has to go back with him on his father's time.
that's fine. I
Okay.
can do that.
And if you can, give it to him as often as possible at your house and teach him how to use it and when to use it. This is the appropriate time to learn lessons. And that's actually a great tool to do so. And one of the reasons that the court has an affinity for leaving the kid with school or the phone is it is a beautiful disciplinary act. You didn't do your homework, the phone isn't given back to you until that homework is done. That and a PlayStation seem to be the things that really get their attention really fast.
Yeah, Roblox, something like that. So
yeah. So all righty. So that should take care of
I'm fine with sending the phone back.
Yeah, please. I mean, it is his property technically because he does own the phone, but it's on loan to the son and it's the son's for use. So it's kind of a gray area. Play it as well as you can, but you don't get to keep it. Okay.
I wasn't trying to. Terrence would Mr.
You give it to the child and the child. You two don't need to give it back and forth.
Okay.
Okay. That should make it easier.
Thank you.
And then, like I said, utilize this as a teaching tool. You've got one of the best teaching tools there is because these kids get really wrapped in this stuff. But like I said, tell them the court ordered you to keep an eye on it. The rule I had with my children was I pay for the phone. When I ask you to hand it to me, you will hand it to me.
Right.
Because I want to know what you're typing, texting, and I want to know all of that. I did it until they were 18. So, as long as they were minors and I had, I also had the ability to shut the phone off. I also had the ability to track them with Find My iPhone. So that way, they're safe and you know where they're at. You don't have to tell them that either. All righty.
All right.
Just go into the locator section of the phone and you can do that. But Terrence, do not locate him when he's on mom's time. And mom, try not to do any locations when he's on dad's time. Okay.
Okay.
In other words, like I said, your parenting time stops at each of your doorsteps.
Okay. All right.
Okay.
All right.
Basically I used to explain physical custody is kind of like driving the car. When you're driving the car, you get to choose the parking place, the gas station, the car wash. That's what parenting time is. When you're driving the car, you make all the choices. The other side doesn't. Only one person can drive the car at a time.
Gotcha.
Okay. It's kind of the quickest, easiest, sloppiest explanation I give to people. So when the child's with you, you're driving. So the other side, the other side doesn't get to choose what meals you make. Okay.
Gotcha.
As a concrete example.
All right.
But yeah, discipline, that's fine. But full takeaway just because you don't want the child to have it at all is a whole other thing, Miss Honorable. If, like I said, use this as a teaching thing. Okay. And Mr. Betts, don't use it as a weapon either. Because I've seen guys do that where they track the child when it's on mom's time. Don't. That's not allowed. All right. And if I find that out, I'm going to have some problems with that too.
Okay.
The two of you have gotten along well enough so far. You've raised a couple good kids, so take care of them and, enjoy them.
Okay.
It goes fast.
All right, sir.
All righty. Take care. Have a great morning. All righty. Bye.
All right. Thank you.
All right. Next.
Bentley's 9 years old now.
Right.
We've had agreements now for 9 years.
Well, yeah. I mean, it's gone back and forth. It's always been reasonable as agreed. There's never been any ordered parenting time from what I've seen in the file.
Right, and that's kind of what I want to go over. Is I want to establish a line there.
And we will do that. Either party has the right to ask for. No, the support cat's welcome. It's okay. You don't have to push him off to the side, Miss Stellini. Support
he knows
animals.
I'm anxious, so he's trying to get up in
No problem.
my lap right now.
If you need to let him get up in your lap, let him get up in your lap. That is fine. So,
come here.
But in any event, so when was the last time you saw this young child?
I seen him on his birthday. Unfortunately, I made some poor decisions about a year ago. I was incarcerated.
Yeah, that was going to be my next question. What happened that made it kind of questionable? It happens. Miss Stellini, what are your thoughts on this?
I have no issue with him seeing him. The issue that we are having right now is I asked him to come get him.
Okay.
I asked him to pick him up, and
typically, sir, I would have you do the transportation that gives you the control of beginning and end. Okay. The reason I'm asking this question is I'm trying to figure out whether to send you to the front of the court for a full investigation, which takes longer, or mediation where you can sit down with a mediator who can help you draft. Because like I've started this, either party has the right to ask for specific parenting time at any time. That way, everyone knows when the child should be with each parent. You know, pickup times, drop-off times, holiday times, all of it. Okay.
Sorry.
Yeah. No, that's okay. I'm just trying to explain the law. Go ahead.
I had agreed to every other weekend. I told him he could start on the 15th, which he can't start this weekend because we all just caught COVID.
Oh no.
So yeah, so we're in a pickle right there. But I did tell him that he could start seeing him on the 15th. I just requested that he come pick him up because I have an autistic 2-year-old who is has severe autism, and she can't be in the car that long. And I asked he come pick him up, and then
what I'll do is the two of you work this out because it's by agreement now, and then I'm going to send this to the front of the court for mediation where they can formalize a set time period for you all. Okay.
And
yes, sir.
And with that, are we going to be able to establish something that's a little bit less gray than what we have currently?
That's what I'm sending you for, is to actually set it down and say, hey, it begins Friday at this time. It ends Sunday at this time. Okay. And the two of you can agree. What I tend to warn people is I know the front of the court's really stuck on this starting and ending times at 6 o'clock, but that kind of is like right in the middle of dinner. Either the kid misses a 5 o'clock dinner so that you can transport him, or they have to eat at 7 o'clock late. So, you know, maybe on Friday, that's okay because everybody's got to work. So, but on Sunday, try and end it maybe at 7, and same with holidays, 7 or 8. See if you can talk to, because they're going to let you control some of the mediation.
Yeah.
The reason that I don't order parenting time on a morning like this is because I don't know either of your work schedules. I don't know the child's schedule.
My son doesn't
I don't
get
want
home
to order
till 4
something
o'clock,
that.
so I just asked that he picked him up at 4:30 at my house.
Those are the things I don't know. But he may not be able to. He may have to work till 5. You know, some of us are stuck till 5. So telling somebody to pick somebody up at 4:30 and they have to work till 5 or 6 isn't going to work.
I mean, whatever time he works, that's totally fine.
Those are the things I don't know. That's why I'm sending you to the front of the court to flesh it out.
Okay.
And there's no charge on them doing the mediation. Okay.
Okay.
And they'll help you write it all out. Good luck. We'll be sending out the paperwork. They'll be contacting you shortly.
Thank you.
Take care of yourselves. Have a great morning.
You too.
Okay, next. We are here in the matter of Shivington versus Shivington. So, Ms. Racine, according to your motion, he did pay her the $60-some-odd thousand in equity, correct?
He did.
And when did he pay that?
Within the time limit.
Okay. So you've been paid. I understand you want him to refinance. My question is, what harm is being done to your client right now?
Just the fact of being on a mortgage.
The fact of being on the mortgage has affected her how?
I'm not able to get a new mortgage. I don't have credit to purchase a new home.
Okay. Where are you checking? Because some banks, the banks tend to not allow you the credit for having the hold harmless clause in the judgment. Credit unions and places like Rocket Mortgage don't worry about that. They take the mortgage as is. That's why I'm asking you what harm. If that is the harm, because I'm trying to do less harm here. Because if I force him to sell it, I may make you pay all the sales costs at this point because he's paid you. So I'm trying to harm you all less. I realize the problem is most people weren't able to refinance over the past couple of years because of inflation and the rates were so high. Mr. Shivington, have you tried to refinance?
I have not, but I've been looking into it. But we're at 7%.
Yeah, I know,
So
and that's
double what I currently have right now. I've never
double
missed
what
a
you currently
payment.
have, but it's
auto enrolled.
But it's down now from the 9% that it was.
Yeah.
And you did sign an agreement to refinance. So I'm going to ask you to follow through with that refinancing, and I'm going to give you 60 days to do so.
Okay.
And then we're going to have a settlement conference to find out where this is at. I'm not taking off the table that I'll sell the house. I'm just saying I don't want to harm the parties by doing so.
Okay.
Ms. Racine, does your client have any proof that she's been rejected for a mortgage?
No, I haven't looked yet because I just sold my
So you
condo.
haven't looked yet. So you really haven't tried either.
My condo hasn't closed yet. It closes the end of this month. So I'm
okay.
financing.
You know, because I'm looking for some actual harm here, not, you know, because he did pay you. He followed through. And like I said, due to the financial market in the past couple of years, most people did not want to refinance. So I understand that. So we've been given some time.
I have also received delinquent notices from his bank that he hasn't paid.
Well, okay, then I would want to, I would want to see those, because those can harm, because that dings both of your credit ratings. Now that's the harm I was looking for.
Okay.
So Mr. Shivington did indicate that he's never been late on a payment. That may or may not be true, but if it's an automatic withdrawal, it'd be kind of weird to be late on a payment.
Yeah,
so those are the things, I'm looking for. I'm looking for harm such as to your credit rating. I'm looking for harm such as you can't get a new mortgage. Just like him, the interest rates are high. So that's not going to be a consequence. But if it's high because of the credit rating ding, that's harm. So Scott, I'm not taking off the table that I will sell the house. I'm trying to give you both a chance here to show me what I need to see to push this. You know, it would be a different thing if he hadn't paid. If he hadn't paid the equity and hadn't followed through with all the other stuff, we would be having a different discussion. But he has followed through. Sometimes we have to deal with contract law here, and sometimes impossibility is a problem. And that means impossibility through the fact that the rates are too high or something else is happening that was not foreseen when this contract was drawn up. Because when this was done in 2021, interest rates were at 2% and 3%. And soon after this divorce went in, the interest rates skyrocketed. So in any event, I will see you for a settlement conference in about 60 days, if that's okay. And we will, that way we're going to get this done. I'm going to give him time to refinance, and then I'll give you time to put together any harm that you have. Ms. Racine, I'll be more than happy to accept that at my office at your convenience.
Okay, will you set the settlement conference, or do you want me to contact?
All right, contact my clerk, Ms. LeVay, and you guys can discuss at time. Mr. Chivington, if you have any evidence that you've been paying the mortgage since 2022 consistently,
Provide that.
Yeah, please provide that.
All right, will do. Thank you, sir.
All righty, and you can read, you know, if it's bank statements, you can redact personal information. Ms. Racine knows to do so, but you can black out like account numbers and other things you don't want seen. What's imperative is that I see that there was a withdrawal to the mortgage company on the proper time and date.
Okay.
And obviously, if he does the refinance, we won't need the settlement conference.
Correct. If you get the refinancing done, Mr. Chivington, there's no need for the settlement conference because everything's done.
Okay.
All righty. Good luck, but you got 60 days.
All right. Thank you, sir.
Thank you. So I'm kind of granting your motion, but we're going to find out. Like I said, pulling a trigger on a Friday morning sometimes harms more people than it helps.
Okay. So do you want me to just put in my order that he must refinance in 60 days, and we're scheduling?
Yeah. And then we're scheduling a settlement conference. Yes.
Okay.
With the understanding that I may or may not still sell the house. Depends on what the issues are. Okay.
Okay. All right. Thank you.
You're welcome. Have a good morning.
Thank you,
sir.
We're here on the matter of Funk versus Funk. Case number 24-04913DS. I'm going to see if I can deal with this without, because normally this is the state's motion. The prosecutor brought this, not you, not either one of you. And since the order was recently entered, normally we would have because this was entered in September of 2024. Normally, did you invite the prosecutor, Mr. Funk?
Did I invite them?
Because this is their case.
Honestly, I don't really understand.
All right, here's what we're here for. Bottom line, the state of Michigan filed a case through the Kent County Prosecutor's Office this year because of state aid being involved in this matter.
Mm-hmm.
The state mandates that child support be set by law.
Mm-hmm.
Okay. Then the state will confiscate part of the child support to reimburse them depending upon the state aid that's involved. So this case was not brought by either one of you. It was brought by the state of Michigan. Okay. They entered an order, and therefore this is the state's order, and it was recently entered. So depending upon what the information is that you have, I may or may not be able to adjourn this matter, or I may have to adjourn it to the prosecutor, or I may have to deny it. It depends. So what is this new information you have that would change an order that was entered into less than 5 weeks ago?
Well, I guess what I'm arguing is she didn't participate in anything to do with the child support, so her income and the time of parenting isn't correct on there.
Well, you participated, correct?
I guess I don't really understand that.
Because what they have is they have you guys at equal time.
Yeah.
They had your income at approximately $2,000 and hers at $2,500 per month.
Yeah.
So essentially, this order is entered only to keep the state aid that's involved. I don't know which of you has it, but because you do have equal time. So what's different? Is it not equal time?
No, it changed before she needed to work more, and so she's had them 51 hours every week, and I've had them 117 hours a week instead of.
And when did that start?
That was probably back in. It was before the holidays.
I don't know why they did this, but you have a judgment of divorce, correct?
Correct.
This should have never been entered. This should have been entered in your judgment of divorce. Is there a different kid here than what was in your judgment of divorce?
No.
Just 2 kids.
Just 2 children?
Mm-hmm.
Why did they bring a support case if there was an underlying? Because you get one judgment, which is your judgment of divorce. You don't get a second judgment, and neither does the state. This should have been, what does your judgment of divorce say as to custody and parenting time?
It was a 50-50. It was I would have them Monday through Wednesday.
Okay, and did this change, ma'am?
I want to say it was before the holidays last year. I was staying in a motel and I did need more help. I didn't like having them there as often. And I went down to having them 2 days a week.
All right, here's what we're going to do. I'm going to set this for a settlement conference where I'm going to invite the prosecutor's office, because I think I may be dismissing this case because you should not have 2 cases involving the same 2 children. The divorce is still an open case, correct? I mean, you were divorced, but the case still exists. Yeah, it's finalized because then it's not dismissed. What I'm asking is, it's still a viable case, and custody and parenting time should be taken care of in that case.
And I always thought that it was, and it was that the arrangement that we had before. Well, and now I'm at a better place where I'm able to go back to the 50-50 timing.
Well, whatever. How long were you off the 50-50?
Probably almost a year.
At least 6 months. Was it a whole year?
Because generally, case law indicates that if it's done within a year, you go back to the original order. They allow you to make adjustments depending upon socioeconomic status, or let's say one of you has an abusive significant other, and you need a couple months to get them out of the house. They allow you to adjust. So it may or may not change, Mr. Funk. It may go back to the week on, week off. I'm going to allow that argument, but I'm going to pull the divorce file and find out what's going on with this, because this case should not exist. So we'll set this for a settlement conference. I'll pull that, and I may relabel this as, we may discuss whether this should be considered a motion for a parenting time and child support and send it to the front of the court. So, but I'm trying to figure out why the prosecutor did this. This is weird. Okay, so I will see you in 2 or 3 weeks, and I'm going to invite the prosecutor to it. Okay, it'll be by Zoom again. It'll be by a settlement conference. Okay, that way we can have an informal discussion and find out how to get this worked out. If the 2 of you work out something on the custody and parenting time between now and then, great. Okay, if not, we'll be sending it to the front of the court, and they may or may not reset it. Okay.
Okay.
All right. Have a good morning. Good luck.
Thank you.
Thank you.
How did the prosecutor bring a case? I didn't even notice there was a divorce case because this is a support case. It's not even listed in this thing. How did they do this? Give me a second. I'm sorry. Just to inform the parties, we are here on a motion by the Kent County Prosecutor's Office on behalf of the state of Michigan. Okay. Neither one of you brought this case. The state of Michigan brought this case because state aid is involved in the case. When state aid is involved in a case, the state mandates that child support be paid by law because they will confiscate part of the support to reimburse the state for the state aid. And I can never tell you how much they're going to confiscate because it depends on which state aid you are on and how much. And I tend not to ask that question because it's not pertinent to the court. It just, as long as state aid's involved, then we have to set the child support. Okay, with that noted, because I always have I started this explanation because I always used to have a lot of people come in and go, well, they started this case. Why did they do this? And I'm like, they didn't. Neither one of you wanted this case. The state of Michigan mandated it. Okay, so that's why Ms. Brower is here as the prosecutor on behalf of the state of Michigan through the Kent County Prosecutor's Office. Ms. Brower, I will let you proceed with your motion, then I'll ask for input from both the parties. Please proceed, ma'am.
Thank you, Your Honor. There was a pre-hearing conference scheduled for October 15th, 2024. The defendant only participated. I called the mother at least a couple of times. She did not answer. If the court recalls, we were here with these same parties approximately 2 to 3 months ago. So I ran guidelines for the new child using the exact same income that I used 2 to 3 months ago. So according to the defendant, all of his income information is still the same. I use the same income information for the plaintiff. The plaintiff is salary, gross is $66,500 per year. Let's see. I considered the health insurance that she maintains. The defendant, like I said, I use the same income for him. It's based on his actual income. I am asking that the court enter the proposed judgment as well as the UCSO.
Of course. Ms. Nix, is there any input you have, ma'am?
Not at this time. You are entering the amount, or you're proposing to enter the amount for the 906.
Correct.
If that's the paperwork I'm looking. Okay.
That's what the state is asking for. Now, how much they will confiscate, I have no idea.
Okay, I'm clear on that.
Yeah, because you will not receive the 906. I don't know how much of it they'll take. I mean, they have been known to take all of it, but it depends on what state aid you're on. So, Mr. Lewis, what are your questions, sir?
I'm just ready to get it done.
Alrighty, no problem. Well, I can always tell you that it's set by law, and by law, it's always too much for you to pay and never enough for her to receive. So, but it comes out to about $208 a week, I think. Okay, because a month is 4.35 weeks. It's not 4 weeks. Okay. Alrighty. In that case, I will enter the order. Ms. Brower, I'll do that by DocuSign whenever you send it to me. Have a good morning to both of you. It was nice to meet you. Just stay safe and have a great weekend. Looks like it's going to be a nice one, so enjoy.
You too.
Okay, bring in the next one. All right, let's go on the record in the matter of Walker versus Meyer, case number 24-007714DZ. This motion was brought by the state of Michigan. And is state aid involved in this matter, Ms. Brower?
Yes, Your Honor. The plaintiff receives Medicaid food stamps as well as cash from the state.
Okay, the reason that I ask that is because it's a DZ case, and sometimes they just bring those because the guardianship court has requested it. So I wanted to make sure before I misstated that the state brought this case. So the state did bring this case.
That is correct, Your Honor.
Yeah, if state aid is involved in a case, the state mandates that child support be paid by law, because the state then confiscates part of the support, depending upon what you get. And they can confiscate a little or they can confiscate it all. Depends on what you get for state aid. So I can never tell you what it's going to be because the state does that figure later, and it's dependent upon what state aid's involved. And since I never tend to ask what state aid's involved because that's your business, I just have to follow the law about it being mandated by law. So I will let the state of Michigan proceed with their motion, and then I will ask for input from each of you. Okay. Ms. Brower, please proceed.
Okay. Your Honor, there was a pre-hearing conference scheduled for October 24th, 2024. Both of the parties participated. The plaintiff is the legal guardian. The defendant earns $18 an hour at 40 hours per week. That's the income that I used for her. Neither of the parties was enthused about the child support recommendation.
Correct.
So, I told them that, if they could articulate a reason that the support recommendation is unjust or inappropriate. If the court wanted to deviate, I wouldn't mind. But at this point, it is
Well,
what
you're the
it is.
representative of the state, so I will allow those arguments to be made.
Okay.
So hold on a second. My computer is acting up. I lost all of you, so hold on. All right, because we're about to get into financial discussions and probably some intense questions, I'm asking